Are you Miss Krujuski? Can you push the button? You're muted. All right, there we go.
Yes.
All right, this is file 25-93350FH, and we've got counsel. You want to state your appearances beginning with people?
Zachary McLennan on behalf of the people.
And James Gilbert here on behalf of Mr. Krujuski.
Okay, we're here for, looks like a docket call and a contempt sentencing, bond having been previously revoked. Mr. Gilbert, what's our status here?
Your Honor, this was also one that our whole intent was to see if we could get her into the recovery court program out in Alpena, because definitely she needs this type of program and structure. And with that disappearing, that has sort of made a change in our game plan. I know we're trying to find possibly some sort of inpatient for her. So the matter has not been resolved. However, I did want to ask, I know she sat quite a while since her bond's been revoked, if the court would consider reestablishing her bond while we try to find out a resolution of this case.
All right, I could set this for a docket call on August 11th at 9:40 a.m. Mr. McLennan, as to bond.
Your Honor, this is a felony OWI case. She's been drinking on bond. I would ask bond to be revoked.
Yeah, I mean, that's the problem here, is because while she was on the supervision of bond and knowing she was subject to all this testing, we had SoberLink and urine tests, and they were showing up positive for alcohol and positive for drugs. So I guess I'm going to leave bond revoked unless I've got some plan of what kind of intense supervision she's going to be under. That's where then maybe when she's on probation, then we can think about, whether she served enough time. But short of that, just making her test while on bond clearly was insufficient to protect public safety. So, Ms. Krujuski, I'm sorry to inform you, I'm not going to reinstate your bond at this time. So we'll continue the contempt sentencing to the same date and time. Anything further from the people?
No, Your Honor.
From the defense?
No, Your Honor, thank you very much.
Okay, we'll see you August 11th.
Honor,
Yes,
in the Pisarski matter,
yes.
the victim did intend to give a statement today. She was supposed to have been here by now. She's not. At least inform the court of that.
Do you know if you had any contact with her where we should, if she's running late or something, or you want us to?
Yeah, she said she would have been here in 15 minutes. That was about 20 minutes ago.
We could pass the case for another couple minutes if you want. She's thought she was en route.
Yeah, we would like that.
All right, let's go off the record. Ready for sentencing and people be Brandon Pisarski. It's file 24-93317FC. Counsel, you want to state your appearances, please?
Zachary McLennan on behalf of the people.
Your Honor, Mike Vogler, representing Brandon Pisarski.
All right, and Mr. Vogler, have you had a chance to review the pre-sentence report and recommendations?
Yes.
Do you have any additions, corrections?
I do, Your Honor. I guess we'll start on the very first page, basic information report. Middle of the page, it says mental health treatment, no. That should be yes.
All right, Agent Lesky, on the basic information report, the CFJ 101, just where it has just the yes or no for mental health treatment, it says no. Defense is asking for that to say yes. Under the narrative portion of the pre-sentence report, it does describe his treatment for a host of mental health issues. So if you could change that to yes. Any other changes? Mr. Vogel?
Yes, on the first page of the pre-sentence investigation report at the top, where it's reciting the plea agreement.
Oh, yeah, where it said the prosecutor dismissed count one.
Yeah.
Yeah. There was a count one had been dismissed by the court on defense motion. So that was not part of the plea agreement. Can you change under the plea agreement, in return, PA agrees to dismiss count two in file 93317. I suppose then you could add a statement at the end that count one had been previously dismissed by the court. Okay, Mr. Vogler, any other changes?
Staying on the same page, Your Honor, where it says psychiatric history. I think that should say yes instead of no.
Okay, Agent Lesky, so I always have a question about this on the first page of the CFJ 145, where it says psychiatric history, yes or no. What triggers that being a yes? Is that some prior hospitalization or just any mental health treatment? Because psychiatric history sounds a little bit narrower than mental health treatment history.
Yes, I do, Your Honor. It's triggered by a computer system where we have to indicate yes or no on that.
Okay, and that would a yes only be triggered if there had been a prior hospitalization, or?
It's generally yes, Your Honor.
Okay. That was sort of my understanding about that there's no psychiatric here, I suppose. So we'll leave that as a no. The report overall does describe accurately the mental health diagnoses and treatment that Mr. Pisarski has received. Any other changes, Mr. Vogel?
Just continuing on then under evaluation and plan again, first paragraph, keeping with the plea agreement, indicates agreed to dismiss count one.
Okay, so Agent Lesky, again, I know you didn't write these pre-sentence reports just coming aboard, but if you can look back and make these changes for us, I'd appreciate it. On the first paragraph of evaluation and plan, the same statement is made with regard to the plea agreement. So if you can just change that, the prosecutor did not agree to dismiss count one as an inducement. The court had previously dismissed count one on motion by the defense.
Then on under the criminal history, number 12 of 13. Figure out what to do about that. That was a case.
Oh, yeah, and then I set aside the conviction. Okay. All right, so Agent Lesky, there's under the criminal history, offense 12 of 13 shows a conviction date of 7/24/24 jury and disposition.
Okay.
However, on appeal, this court set aside that conviction and remanded for new trial. So I think that should no longer reflect a conviction and should not have a disposition. And is the matter still pending, Mr.
It's
McClellan?
been dismissed.
And then it was dismissed as part of this plea, is that right?
Correct.
Okay. Yeah, so actually the disposition could be that case was dismissed. It should not show a conviction. Any other changes, Mr. Bogdan?
Yeah, going on to page 9 with the marriage caption. Box here where it indicates the daughter, age 6. That would not be his daughter. He doesn't. He has a child on the way, but he's not his daughter.
That was his former significant other's daughter then? All right, so Agent Lesky, under the marriage portion of the pre-sentence report on page 9, the information in the chart does appear to be inconsistent with the narrative. The narrative describes no children of his own, but the chart does include a child. If you can just strike that daughter from that chart, apparently it is not his daughter. Mr. Vogler?
Okay, Your Honor. So on page 10, vocational / other training, where it says level completed 9th grade. I don't think that it's, I don't think it's 9th grade. I think it's still a pending certification endeavor, where he is, and it wouldn't be general studies, that would also be off. He's actually, the Ross College thing is an attempt to be certified in medical building, and that's required as part of his.
All right, let's talk about that. This hearing in People v. Brandon Pisarski was textbook meticulous courtroom work, with Judge Aaron J. Gauthier leading the way. We got a solid look at what happens when all parties come prepared to fine-tune. The details, and I do mean details. Judge Gauthier was in full editor-in-chief mode, reviewing and correcting the presentence investigation report line by line with input from defense attorney Mike Vogler, prosecutor Zachary McLennan, and agent Lesky, who inherited the PSI and handled the updates with grace. First off, mental health treatment was marked no, despite the narrative clearly stating that Mr. Pisarski had received treatment for various mental health concerns. That was quickly corrected to yes, as it should have been. Then there was a clerical mix-up about the plea agreement count 1 had been dismissed by the court on a defense motion, not as part of any plea bargain. Judge Gauthier caught that and made sure the record reflected the truth, not just boilerplate language, and it didn't stop there. We had a back and forth on what qualifies as psychiatric history versus general mental health treatment, a reminder that labels matter in legal documentation. The judge probed the terminology and decided to keep psychiatric history marked as no, while still acknowledging the broader treatment history in the narrative. They also corrected the criminal history section where a prior conviction had been overturned and ultimately dismissed. That one was a big deal. It changed the nature of Mr. Pisarski's record and needed to be reflected accurately. Even the family info got a cleanup. The report incorrectly stated he had a 6-year-old daughter, but as it turns out, that was a former partner's child. One more item to strike? Educational background? Same deal. He wasn't a 9th grade dropout in general studies. He's currently pursuing a certification in the medical field through Ross College. Again fixed. This wasn't a high-drama hearing. No outbursts, no last-minute surprises. Just a professional and collaborative effort to get the paperwork right before sentencing. And that matters because when someone's liberty is on the line, the record needs to be bulletproof. Judge Gauthier handled it with calm authority, making space for everyone to speak and ensuring that even the smallest details were properly addressed. Mr. Vogler came prepared and thorough. And agent Lesky was responsive and efficient in taking those edits on the fly. The atmosphere was calm, focused, and respectful, exactly the kind of courtroom setting you hope for in a case that's all about getting the facts straight. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read everyone,